constitutions. So simply saying that it is a legislative issue.
Welcome to the live, everyone. And thank you for your love and support. Tosh, are you here?
I am. Thank you for having me.
Wonderful. Thank you for coming in. Everyone will be here on standby for the Arbery sentencing for the Ahmaud Arbery. And the three men that sit before you have been found guilty. So we're standing by. Let's listen in.
That was their argument. It is repugnant to our entire system of criminal justice. I asked the court to grant the motion.
Right. And I didn't hear the argument quite that way, where the court has to defer to the legislature. There is a structure in place with regard to sentencing, and this court intends to adhere to that structure as established through Georgia case law. On that basis, the motion is denied. I understand those are all preliminary matters, and before the court is the mitigation, if they wish to do so, and make argument with the state then having the rebuttal. That's how I understand we're going to proceed. From the state.
Your Honor, for the record, today is Friday, January 7th, 2022. The jury returned its verdict on November 24th, 2021. That verdict was that Travis Mcmichael was found guilty on all 9 counts in the indictment. Greg Mcmichael was found not guilty of count 1, which is malice murder, but guilty on the other counts 2 through 9 in the indictment. Mr. Bryan was found guilty only as to counts 3, 4, and 5, all felony murder counts, and the underlying felonies corresponding to those felony murder counts, which were counts 7, 8, and 9. The court asked all of us to look into, with regard to Travis Mcmichael, the issue of potential merger as to the malice murder charge. The state has reviewed its own indictment and notes that it charged Travis Mcmichael, who was found guilty of count 1, malice murder, a human being did unlawfully, with malice aforethought, caused the death of Ahmaud Arbery, a human being, by unlawfully chasing him through the public roadways of the Satilla Shores neighborhood in pickup trucks and shooting him with a shotgun, contrary to the laws of said state, the good order, peace, and dignity thereof. As the state notes, this encompasses 2 different actions. Unlawfully chasing him through the public roadways of Satilla Shores, which describes the actions they did in the pickup trucks, and then shooting him with the shotgun. As the court will recall, defense filed a demurrer to count 1, saying this was surplusage and should be removed. The state's argument was that the state was not going to argue it was an either-or situation, and that is not going to be the state's argument here. The state's argument here is that factually, the state believes that count 8, false imprisonment, factually has been eaten up by the way the state charged count 1 in this indictment. In other words, count 8 and count 6 would merge into count 1 for Travis Mcmichael on the malice murder charge because of unlawfully chasing him, meaning Mr. Arbery, through the public roadways of the Satilla Shores neighborhood in pickup trucks. The reason we believe that factually would merge is because count 8 is actually the false imprisonment charge. And count 8 does say, said accused did chase Mr. Arbery with a Ford F1 pickup truck and a Chevy Silverado pickup truck through the public roadways of the Satilla Shores neighborhood and did confine and detain Ahmaud Arbery. As the court is aware, the statute has nothing to do with chasing. That is descriptive language factually. The statute has to do with confining and detaining the victim. The fact that the state used up factually both the chasing in count 8 and the chasing in count 1 means both count 6 and 8 would then merge into count 1. I believe, and I could be wrong, but I will address this, that the defense may argue that count 7 and count 9 would also then merge into count 1 malice murder. However, the state's argument is that is not the case. The reason for that is count 7, the aggravated assault with the pickup trucks, did make an assault upon the person of Ahmaud Arbery. An object, device, or instrument, when used offensively against a person, is likely to result in serious bodily injury. That, of course, factually can be a number of different things. And what the state did argue in closing argument was pulling up next to somebody, startling them, could put them in reasonable apprehension of receiving serious bodily injury. The state also argued in its closing argument that Travis Mcmichael, despite his testimony, actually used his pickup truck to pull in front of Mr. Arbery and cut him off, which caused Mr. Arbery on Burford to turn around and run away. So the fact that the jury found that they used their pickup trucks, objects which used defensively against a person are likely to result in serious bodily injury, did create an aggravated assault for Mr. Arbery, does not merge into count 1, which was unlawfully chasing him through the public roadways of Satilla Shores in pickup trucks. They are two separate and distinct things, especially when we have video evidence of the Mcmichaels pulling up next to Mr. Arbery, Mr. Arbery then running away. That itself right there is an aggravated assault. He was obviously startled. He obviously was trying to get away from these men. They pulled up next to him. Reasonable apprehension of receiving serious bodily injury. With regard then to count 9 is criminal attempt to commit the felony of false imprisonment. As the court will recall, the defense also demurred to that particular charge in the indictment. That particular charge in the indictment did have an "and" in it, which, as the court knows, is an "or," which the state explained in its closing argument to the jury. In this particular count 9, it did charge the defendants with unlawfully chase Ahmaud Arbery through the public roadways of the Satilla Shores neighborhood in pickup trucks and did attempt to confine and detain Ahmaud Arbery without legal authority on Burford Drive using a Ford F-150 pickup truck. In this particular instance, the state did argue and did inform the court in the demurrer response that it was going to argue "and" or, because as we know, a criminal attempt is just a substantial step toward committing that particular felony. And as the court will note, count 8 took place on Holmes Drive, whereas count 9 was on Burford. So they don't have anything to do with each other. They're two separate incidents at two separate points in time based on the evidence in this case. So either one could be considered a substantial step, and because the "and" in between unlawfully chase and did attempt to confine and detain is really an "or" for the purposes of this. And once again, the state put that in its response to demurrer by the defendants, and the court denied the demurrer. That was filed by the defendants. The state also argued in closing argument that that was an "or." They could find it that he was chased. They could also find that on Burford they did attempt to confine and detain him, especially with Mr. Bryan's actions of trying to run him off the roadway from his driveway, and with Mr. Mcmichael's actions of cutting him off at the end of Burford. So in this particular instance, especially with the criminal attempt, it does not merge into malice murder simply because of the words "did unlawfully chase him through the public roadways" contained in count 1. Therefore, when it comes to Mr. Travis Mcmichael, the state's position on sentencing and merger is this: that he is looking at a life sentence on count 1, malice murder, that counts 2, 3, 4, and 5, all felony murder, would be vacated by operation of law. Count 6, which is the aggravated assault with the shotgun charge, would factually merge into count 1. Count 7 would remain standing. And count 7 is a potential sentence of 1 to 20 years on the aggravated assault with the pickup trucks. Count 8, in the state's opinion, would factually merge then into count 1. False imprisonment, of course, is a 1 to 10 potential sentence. And count 9 criminal attempt cuts that sentence in half. So count 9, criminal attempt to commit false imprisonment, is a potential of 1 to 5 years. Therefore, the minimum sentence that this court could impose on Travis McMichael would be life with the possibility of parole with 15 years, and that court could suspend, probate, run concurrent with that particular sentence. The maximum, and that is what the state is asking for in this case, is a life without the possibility of parole. The state did file its notice of its intent to seek life without the possibility of parole back in 2020 when this case was first indicted. So the state is seeking life without the possibility of parole as to count 1. Counts 2 through 5 are vacated by operation of law. Count 6 would merge into count 1, leaving then count 7 and 9, which would be 25 years. We are asking that that 25 years be a 25-year sentence, but to be run concurrent if the court chose to impose a life without the possibility of parole sentence. And that would be count 7 concurrent with count 1, 20 years to serve. Count 9 concurrent with count 1 consecutive to count 7, thus making it a total of 25 years running concurrent with the life without the possibility of parole sentence on count 1 for Travis McMichael. And that is what the state will be requesting and seeking. With regard to Greg McMichael, he was found not guilty on count 1, malice murder. He was then found guilty of counts 2, 3, 4, and 5, all felony murder. The state is seeking, therefore, a life without the possibility of parole sentence on count 2, which is felony murder based on count 6, which is the aggravated assault with the shotgun. Counts 3, 4, and 5 would be vacated by operation of law. Count 6 would merge into count 2, the felony murder. In this particular case, that felony murder only alleges did cause the death of Ahmaud Arbery based on the aggravated assault with the shotgun. So we do not have the same issue with language of chasing in count 2 of this indictment. This would, of course, leave count 7, count 8, and count 9 available for sentencing. Count 7 is aggravated assault with the pickup trucks. That's a potential 1 to 20-year sentence. Count 8, false imprisonment on Holmes Drive, a 1 to 10-year sentence. Count 9, criminal attempt to commit false imprisonment, a 1 to 5-year sentence. So the minimum Greg McMichael is looking at is life with the possibility of parole and 35 years. That 35 years can be run concurrent, it can be probated, it can be suspended. The maximum Mr. Greg McMichael is looking at is count 2. The state is going to be asking for life without the possibility of parole. Counts 3, 4, and 5 are vacated by operation of law. Count 6 would merge into that life without the possibility of parole sentence, and the additional 35 years to be run concurrent consecutive, meaning count 7 concurrent with count 2, 20 years to serve. Count 8 concurrent to count 2, consecutive to count 7, and count 9, the 5 years to serve, concurrent with count 2, consecutive to count 8, resulting in a 35-year sentence to be run concurrently with the life without the possibility of parole sentence on count 2. With regard to Mr. Bryan was found not guilty of counts 1 and 2. He was, however, found guilty of the 3 felony murder counts, count 3, 4, and 5, based on aggravated assault with a pickup truck, false imprisonment, and criminal attempt at false imprisonment. The state is looking at a life sentence on count 3. Counts 4 and 5 would be vacated by operation of law. He was found not guilty on count 6. Therefore, count 7, the aggravated assault with the pickup truck, would merge into count 3, because count 3 is the felony murder based upon count 7. So count 7 would merge into count 3. Count 8, false imprisonment, potential 1 to 10-year sentence, and count 9, a potential 1 to 5-year sentence. Therefore, the minimum Mr. Bryan is looking at is a life with the possibility of parole sentence, plus an additional 15 years, which once again can be run concurrent, It could be run consecutive. It could be probated and or suspended. In this particular case, the state is going to make a recommendation for Mr. Bryan of life with the possibility of parole on count 3, with 15 years to serve consecutively on probation. And that is going to be our recommendation for Mr. Bryan. Your Honor, at this time, the state will go ahead and present its victim impact evidence for the court's consideration, and then once that's through, we will make our argument. Thank you. At this time, we're going to present Mr. Marcus Arbery.
I do want to make a point before we get into the victim impact statements, and not to imply that this would go any other way. But I do want to make sure that those that are addressing the court address the court as opposed to anybody else in the gallery. So let's go ahead and proceed. Good morning.
Good morning. How y'all doing? Right. It's a hard time with me and my family. You know, something that I just doesn't sit right with me at this time. The man who killed my son has sat in this courtroom every single day next to his father. I'll never get that chance to sit next to my son ever again. Not at a dinner table, not at a holiday. And not at a wedding. He'll never get to have I pray that no one in this courtroom ever has to do what we had did, that buried their child. There's no word for that, because no word knows that much pain. Not only did they lynch my son in broad daylight, but they killed him while he was doing what he loved than anything, running. That's when he felt most alive, most free. And they took all that from him. When I close my eyes, I see his execution in my mind over and over. I'll see that for the rest of my life. When I became a father, my life became bigger than me. It became about my family, about protecting him, protecting my boy. I know in my head that there's nothing I could have done that day to have saved my son, to have protected him from that evil and hate. But my heart is broken and always will be broken, because on my worst day, or our lives, wasn't there. If I could, I have trade places with Ahmaud in a heartbeat, but I can't. So I'm standing here today to do what he can't, and that is to fight for him, fight for his memories, his legacy, and to tell you who he was, because that's the one thing you didn't hear in this courtroom. And more than anything else, you should know who my boy was. We love our son, and we will never have him with us to celebrate anything. Thanksgiving, Christmas, for his birthday. His kids should spend the rest of their lives thinking about what they did and what they took from us. And they should do it from behind bars. Because me and my family, we got to live with his death the rest of our life. We'll never see Ahmaud again. So I feel they should stay behind them bars the rest of their life because they didn't give him a chance. Thank the court. Thank y'all for what y'all did with our family stuck by us. Thank the jury. I give all glory to God. Thank y'all.
Thank you, Mr. Arbery.
Ms. Jasmine Aubry.
Good morning. My name is Jasmine Aubry. Ahmaud is my brother, and I would like to tell you a little about him. Ahmaud had dark skin that glistened in the sunlight like gold. He had thick, curly hair, and he would often like to twist it. Ahmaud had a broad nose, and the color of his eyes was filled with melanin. He was tall with an athletic build. He enjoyed running and had an appreciation for being outdoors. These are the qualities that made these men assume that Ahmaud was a dangerous criminal and chase him with guns drawn. To me, those qualities reflected a young man full of life and energy, who looked like me and the people I love. Ahmaud was funny. He told jokes to lighten the mood because he was a positive thinker. Ahmaud had a big personality and never missed the opportunity to let it shine. Ahmaud had a future that was taken from him in the instance of violence. He was robbed of his life pleasures, big and small. He would never be able to fulfill his professional dreams, nor would he be able to start a family or even be a part of my daughter's life. The loss of Ahmaud has devastated me and my family. So I'm asking that the man that killed him be given the maximum sentence available to the court. Thank you.
Thank you, ma'am.
Ms. Wanda Cooper-Jones.
Good morning.
Good morning, Your Honor. I want to first speak directly to my son, if I please. This verdict doesn't bring you back, but it does help bring closure to this very difficult chapter of my life. I made a promise to you. Today, I laid you to rest. I told you I love you, and someday, somehow, I will get you justice. Son, I love you as much today as I did today that you were born. Raising you was the honor of my life, and I'm very proud of you. Your Honor, these men have chose to lie and attack my son and his surviving family. They each have no remorse and do not deserve any leniency. This wasn't a case of mistaken identity or mistaken fact. They chose to target my son because they didn't want him in their community. They chose to treat him differently than other people who frequently visited their community. And when they couldn't sufficiently scare him or intimidate him, they killed him. My youngest son, he was born on Mother's Day of 1994. He had a smile so bright it lit up a room. He was a greedy baby that seemed like he was always searching for something to stick into his mouth. He was always a loving baby who seemed to never tire of hugs, cuddling, and kisses. He loved, he never hesitated to tell me, his sister Jasmine, and his brother Marcus that he loved us. And Your Honor, we loved him back. He was messy. He sometimes refused to wear socks or take good care of his good clothing. I wish he would have cut and cleaned his toenails before he went out for that jog that day. I guess he would have if he knew he would be murdered. My family is going to miss Ahmaud. We're going to miss his jokes, his impersonations, his warm smile. These men deserve the maximum sentence for their crimes. Ahmaud never said a word to them. He never threatened them. He just wanted to be left alone. They were fully committed to their crimes. Let them be fully committed for the consequences. Your Honor, I'm standing here for you as the mother of Ahmaud Arbery, asking you to please give all three defendants who are responsible for the death of my son the maximum punishment in this court, which I do believe is life behind bars without the possible chance for parole. Thank you.
Thank you, ma'am. Any additional evidence and aggravation from the state?
No more additional evidence from the state, Your Honor.
Argument?
Your Honor, the state is seeking life without the possibility of parole for the Mcmichaels based primarily on the evidence presented in this case. The state is not going to go through all of that evidence, just a few very important items. First off, there was a demonstrated pattern of vigilantism by Greg and Travis Mcmichael. First off, we have our July 13th, 2019 911 call after both of them went with guns to confront a homeless man who was living under the bridge, who they suspected must have been committing all of these crimes. Of course, all of these crimes included a lot of reports to 911 about suspicious persons. And as we heard from the witness stand and defense witnesses, a couple of unlocked cars with things stolen out of them by people outside the neighborhood. And then we have February 11th, 2020. Yes, Ahmaud went inside of the open, unsecured construction site that particular day. But Travis Mcmichael went home got his father, they both got their guns, and then they went back down to that construction site. We know that because we heard the 911 call. And he says, I'm sitting outside the construction site. He talks about seeing somebody inside with a flashlight. The horrible part is we know from Brooke Perez, who testified for the defendants, that her husband had gotten a call from Larry English, and he'd gone over there with his handgun. We also know that the two men went inside with their handguns. It's a miracle they didn't shoot each other. And no one had called the police. Travis is outside in the pickup truck, finally calling the police. He stays on for about 4 minutes, and then Officer Ash appears. That didn't teach anybody here a lesson at all. Brooke Perez was trying to tell them, no, my husband's over there with a gun. Be careful, go in there. But Greg Mcmichael took off, according to Travis's statement, down the street and went right into that house. So we've got July 2019, February 11th, 2020. Not calling 911 first, not staying home, but wanting to seek out, in a vigilante manner, a confrontation with people that they suspect might be doing something that they themselves, up until January 1st of 2020, had not been the victim of. In all cases, they took firearms with them, did not stay home, did not allow the police to do their job, but instead, as on February 11th, Greg Mcmichael went in and started searching the house himself. We all know that how that could have turned out terribly for him, for anyone in there, and for Diego Perez. All the decisions they made that led up to the death of Ahmaud Arbery. There were so many opportunities to stop, to think. And here's the real problem. Greg Mcmichael was former law enforcement, as they pointed out repeatedly. And Travis Mcmichael had served in the Marines. I'm not the Marines, the Coast Guard, as they pointed out repeatedly. So here we have some men who should have known better. Should have known better. Vigilantism always goes wrong. You wait for the professionals to show up. The professionals who are in marked cars, the professionals who are in uniforms, the professionals who are going to do it right because they have something to lose, the professionals with body cams, the professionals such as Officer Rash, who just would have stopped Mr. Arbery and said, hey, I'm going to put you on the phone with Larry English so Larry English can tell you to please not to come back. And they should have known that. They had alternatives. They had choices. But instead, Travis Mcmichael, who stated he was putting his son Everett down for a nap, who stated that his father had all these medical and health problems, didn't say, no, Dad, I'm putting Everett down. No, Dad, you need to stay here. He grabbed his shotgun, which he stated was propped up in a corner in that house, to go with his father. And Greg Mcmichael was willing to get into that pickup truck and sit in a child's seat to go chase after Mr. Arbery. Greg Mcmichael attempted to control the narrative from the get-go at the scene. His statements were all about how they were justified, how it was self-defense, how Mr. Arbery attacked his son. When the unknown man came up to Greg Mcmichael at the scene, because of course the police hadn't put Mr. Mcmichael anywhere, told him not to talk to anybody. He was running around the scene talking to everybody. And when talking to this unknown man who walked up to give him water, he basically said, no, this guy's an asshole. He is 20 feet from Mr. Arbery's body, referring to Mr. Arbery as an asshole. There's been no remorse shown, and certainly no empathy from either man Because empathy would have said, hey, how must this look to this person that we're chasing? Are we terrifying this person? Are we scaring them? No empathy for the trapped and terrified Ahmaud Arbery. There was thoughtlessness as to the consequences, thoughtlessness as to the alternatives. There was vigilantism. And because of that, we are asking for Travis Mcmichael and Greg Mcmichael to be sentenced to life with the possibility of parole. Travis Mcmichael on count 1, malice murder, Greg Mcmichael on felony murder count 2, with the prior sentences or the underlying charges to run concurrent consecutive per the state's prior statement. The state is going to guess that the defense will probably say that these men served their country, they served the community. Travis in the Coast Guard, Greg Mcmichael at the district attorney's office, but we all know it is not the 99 things you do right, not the 99 good deeds that you do. But when you take another person's life, it can't be undone. It can't be taken back. There is no do-over. It's final. And that means caution must prevail. Thoughtfulness, empathy, and insight must prevail, not vigilantism. With regard to Mr. Bryan, his actions speak for themselves. He contributed to the death of Ahmaud Arbery in a significant way. The court is familiar with his actions. The court is familiar with his statements, with his level of cooperation with Agent Seacrest afterwards. And given his actions and statements in this case, the state is asking for a life with the possibility of parole sentence. And that would be on count 3 with 15 years consecutive on probation for Mr. Bryan. Thank you, Your Honor.
Yeah. Mr. Rubin.
Thank you, Your Honor. Your Honor, for 150 years,
judges in cases in which defendants were convicted of murder were authorized to impose a life sentence. That was the only sentence available. In 2009, the legislature expanded the judge's discretion and now allows a judge to impose both a life sentence with the possibility of parole and a life sentence without the possibility of parole, and gives absolutely, as Mr. Goff pointed out, no guidance to the court as to what factors to take into account when differentiating between people convicted of murder. But I know this court, Your Honor, has been on the bench long enough and has tried a number of cases, including murder cases, in which you've had to make those decisions. And you've had to differentiate between defendants and be consistent in your rulings, in your sentencing, probably the hardest thing any court has to do, which is to sentence a person to time in prison. In this case, in which the state is seeking the harshest possible sentence allowable under the law, we're asking the court to reserve the harshest possible sentence under the law for those who deserve it, for the worst of the worst. When the facts of the crime show a darkness of soul, a person so depraved and heinous as to shock the conscience by their actions, or where the offender is such a danger as evidenced by his past conduct or by his actions post-offense, such that rehabilitation is remote or impossible, those are the offenders who deserve the harshest possible punishment under the law. Those are the offenders who people would argue deserve to spend the rest of their lives in prison. Neither of those scenarios encompasses Travis Mcmichael or the conduct for which he was convicted. And like Ms. Donikoski, I want to spend just a couple minutes reviewing the conduct for which he was convicted, because I agree with something she said, maybe for the first time in this trial. When Travis Mcmichael woke up on that Sunday morning with his son Everett in his house, his goal was not to go out and kill somebody. His goal was to play with his kid. When he sat down for lunch with Everett, possibly with Greg and his mom, Lee, and sister Lindsay, his goal was not to commit a crime that day or kill somebody that day. His goal was to have a family afternoon. And when he was putting his son down at 1 o'clock or so in the afternoon, he was doing what every single person wants to and should be doing, which is taking care of their toddler son. When he got in the truck at his father's behest to find out who that person was sprinting down the road, his goal still was not to commit a crime. His goal still was not to hurt that person, but to merely investigate, to find out what was that guy doing back at the house where Matt Albanzi was motioning. And then 4 minutes later, Mr. Arbery's dead, Mr. Mcmichael's covered in blood, and we have what we have here and what the jury heard. And he was convicted. The jury found that his actions constituted malice murder, felony murder, and the underlying felonies. But this is not a case in which he just targeted someone recklessly, targeted someone without knowledge, misidentified someone. He knew Ahmaud Arbery. He had encountered him previously. And he had known about the fears that the neighbors felt at Mr. Arbery's continued presence. I'm not going to retry the case. The jury found that those facts did not add up to probable cause and did not justify Mr. Mcmichael's actions. But he didn't just go out and shoot Mr. Arbery. He only fired the shots, the fatal shots, when Mr. Arbery came at him and grabbed the gun, as Dr. Donahue demonstrated. These were not, and as reckless as those acts may have been, as Ms. Dunikoski pointed out, as thoughtless as they may have been, they are not evidence of a soul so blackened as to deserve to spend the rest of his life in prison. This was not a planned murder. This was not a murder involving torture. It was a fight over a gun that resulted in Mr. Arbery's death. And for that, the jury found Mr. Mcmichael guilty. The state contends that 99 good acts don't overcome one bad act. And of course, legally that's true. Mr. Mcmichael is now a convicted felon. But 99 good acts do weigh in this court's consideration, do factor into what choice this court is going to make when sentencing Mr. Mcmichael to either spend the rest of his life behind bars or give him the possibility of redemption. And those acts, those 99 good acts, the court heard about those in the bond hearing. The court heard that during his time as a lifeguard at a camp for kids who are who have family members with terminal illnesses, that Travis Mcmichael actually saved the life of a boy who was drowning in the pool. The court heard that Mr. Mcmichael, while serving in the Coast Guard, literally saved the lives of family members who were on a boat that was taking on water. The court heard that Mr. Mcmichael saved the crew of a Coast Guard vessel while serving in the Coast Guard. The court heard of the letters of commendation given to Mr. Mcmichael by his superiors for various acts that the superiors said show superior dedication, selfless devotion to duty and consideration of others, and adherence to our core values, honor, respect, and devotion to duty. They don't excuse anything that happened on February 23rd, but when the court is weighing in the scales of justice what people deserve to spend their lives and then die in prison versus those people who deserve to be punished but then hold out hope for redemption, those are the acts the court should consider. Mr. Mcmichael was a devoted father to Everett. He had Everett 50% of the time, shared custody with Everett's mom, and in fact, early on was shown to be the more reliable parent, although I know that changed over time with his mom stepping up. He was a friend to many people who are now too scared to come to court and speak on his behalf. As the court knows from the testimony it heard in trial and at the bond hearing, he was always a hard worker, always had a job, never laid around letting other people support him, always paid taxes, always supported his community in a variety of ways. The discovery that we received is replete with FBI and GBI interviews of people in his community, people who told law enforcement officials of the times Mr. Mcmichael helped them when they were having problems, when their boat became unmoored, or when their docks were pulled off from storms, and Mr. Mcmichael was out there finding those things and bringing them back to the owners, or helping other people in the community, just as he thought he was doing on February 23rd. Actions that, in hindsight, turned out to be thoughtless, as Ms. Dunikowski said, were reckless, but were not evidence of an abandoned and malignant heart. Nothing in Travis McMichael's life suggests that he's a danger to society now, or will be a danger to society 30 years from now, after he has time to think, to work, to grow. When he's in his 60s, older than me right now, do we still want a person like Travis McMichael behind bars? There's nothing in his post-offense conduct that shows that he's either mentally unstable or a sociopath. He cooperated fully with police. He told the police everything he knew to tell them because he thought he was doing the right thing, even if that thing turned out not to be right. He and Greg McMichael thought they were helping their community. They thought they were helping the police catch someone who inexplicably had been in a house, and we still don't know what he was doing in the house, on 4 or 5 different occasions. He never fled. He never tried to obstruct the investigation. When he talked to his neighbors about what happened, he always expressed remorse and disbelief. If life without parole is reserved for the worst of offenders, those who are so scary, so unpredictable, and so likely to pose a threat in the future, then it is not appropriate for someone like Travis McMichael. The only purpose of a life without parole sentence, Your Honor, is vengeance. It's retribution. And the urge to seek vengeance is strong and understandable in the family. Lord knows if I was in their position, I would be seeking the same thing. But vengeance is not the foundation of our sentencing in our criminal justice system. Redemption is. Redemption is the belief that a person can learn, can grow, and still contribute after punishment. It is pointless to continue to punish a person who has undergone changes in character that distance him from the person who committed the crime decades previously. Travis McMichael, 35 years old now, should have the opportunity to show that he's grown, to show that he's changed, and the parole board, years from now, is in the best position to determine whether he should remain behind bars or can serve a useful purpose to society. Who knows where we will be as a society in 30 years? Why make a decision today that impacts so many people long after we're gone, long after you and I are retired, hopefully, but that binds the hands of those who will have to live with this decision 3 decades hence? Why make a decision today that snuffs out all possibility of growth, of redemption in Travis McMichael? Compassion for Travis McMichael and the humility to admit that we don't know what's going to happen in the future doesn't diminish the compassion that we feel for Ahmaud Arbery's family. Their loss is real and understandable. And their desire for the maximum punishment is real and understandable. But again, that's why we have judges imposing sentence and not the families of the victim. Because there are a lot of factors this court takes into consideration: deterrence, rehabilitation, retribution. Those are all valid factors. But the only thing an LWOP sentence serves is retribution. Wouldn't it be healing for Mr. Arbery's family, for Travis McMichael to atone, to be able to express the remorse that's in his heart without the specter of a federal trial hanging over his head? We've heard several times today that he's shown no remorse, but this court knows that no lawyer would allow Mr. McMichael to say anything about his feelings towards the family while there were 2 pending murder trials against him. When the witnesses were interviewed by law enforcement about Mr. McMichael's conversations with them, to a person, they said that he showed remorse, that he never wanted to kill somebody. He was merely trying to detain Mr. Arbery for the police. It is disingenuous and unfair to expect Mr. McMichael to express remorse with yet another trial beginning in 3 weeks, where everything he says can be used by the federal government against him. Wouldn't it be powerful, though, for Travis McMichael to look deep into himself and explore with the public, with his son Everett, why he did what he did, and in fact become a force for good while in prison and out, instead of one more old man behind bars costing taxpayers $50,000 a year or more in 30 years? Wouldn't it be healing to society for someone like Travis McMichael to be free to help heal the wounds that are certainly present in this country due to decades and decades and decades of discrimination, of racism? Wounds that we're just now beginning to try to heal. Judge, you can send a message that 4 minutes of conduct does not erase a life well lived, and that after punishment, there is opportunity for redemption, an opportunity that Travis can either take advantage of and prove himself worthy or not, and that the parole board can then determine whether he should be released from prison. We are not asking you to do anything, Your Honor, but to agree that we don't know today what the future holds. We're asking you to sentence him to life with the possibility of parole if it's earned. Judge, as far as sentencing, I would disagree with the state. I believe count 7 and count 9 do merge. I believe the language of chasing Mr. Arbery through the Satilla Shores neighborhood that is stated in count 1 and also stated in counts 7 and 9. Were used up, were subsumed, and would be therefore would effectuate a merger of those crimes. In either event, this court has wide discretion in how it fashions this sentence. And we'd ask the court to exercise this discretion in favor of growth, in favor of redemption, in favor of hope, for not just the Mcmichael family, for not just Everett McMichael, but for the Arbery family and what Travis McMichael can prove himself worthy of in the future. Thank you, Your Honor.
Thank you. All right, I think we're probably at a good breaking point. Let's go ahead and take a break, let everybody get some lunch. We will plan on reconvening at, let's do 1 o'clock. It's just before 12 o'clock now, and we will continue with proceedings at that time. Thank you, everybody.
All right, so lunch break. This is going to be, I've been hearing the impact statements. The defense saying that 4 minutes of misconduct, in their words, does not erase a life well lived, asking for the hope for redemption, saying that the actions of these men were not among the harshest of criminals, the worst of offenders, and they deserve
Okay, we're going to be
redemption and
on
do not
lunch break,
deserve to die in
guys.
prison. The Arbery family
All right, I'll be on standby.
impact statements.
All right,
And
Tosh.
Ahmaud Arbery's
And
father, Marcus Arbery,
everyone,
saying, quote,
we're going to
"When I
break
close
back.
my eyes, I
So
see
just
his
stand by,
execution over and over,
or
and
we'll
I'll
just
see
come
it
back. That's
for
what
the
we'll do.
rest of my life."
We'll be back.
Ahmaud will never
Sounds
get a
good.
chance to get married and do other things that young men do.
Thank you for coming,
Saying that they
Tosh, and for your
absolutely are
support. We
asking
can't do it
for
without you.
life in prison without the possibility of parole. Before we take a quick break, I want to bring in former DeKalb County Prosecutor Robert James to talk through everything we just heard. What stands out most to you as now Judge Timothy Walmsley takes everything he's heard to make his final determination of the sentencing in this case?
Well, he's going to have a tough decision. As previously stated, look, I watched it, the victim impact statements of Ahmaud Arbery's family. It's powerful, among the most powerful I've ever